My name's Leah Furch. I've been doing the business entity lecture here for, I guess, 9 years now, as Sarah keeps reminding me today. It generally doesn't take that much time. We usually go through it in about 2 hours. I tend to talk fast, so if you start to get behind, tell me. I won't be insulted. I know I talk fast, so no worries. We're going to start with corporations, and then kind of continue on through the other business entities. OK? My email's on the front. You can feel free to email me if additional business entity or bar questions or whatever comes up. Pretty compulsive about it, so feel free. OK, so corporations. We're going to start with the general corporate characteristics. The first characteristic is that a corporation is a separate juridical entity, which means it's an entity separate from its officers, directors, and shareholders. In order to begin this separate existence, the incorporators must file the Articles of Incorporation with the Secretary of State. Corporate existence begins upon filing. Okay. If a person acts with actual knowledge, that the articles have not been filed, he is jointly and severally liable for all liabilities. Yeah.
Question. In reading over some of the bar review stuff I had, it's my understanding that joint and several liability is no longer applicable in Florida?
It still exists in our corporate statutes. So until the legislature cleans that up for corporation purposes, okay, there's joint and several liability. There's a couple different statutes you'll come across that have joint and several liability. There's some in the wills statutes. There's some in the corporation statutes. So yeah, until the legislature takes care of all of that. Yeah. What they really should have done is gone through and amended every place that that's mentioned, and that didn't happen. So you have to sort of assume that they intended to keep joint and several liability for these purposes. Okay? Okay, so if a person acts with actual knowledge that the articles have not been filed, he is jointly and severally liable for all liabilities incurred while so acting, unless the third party also had actual knowledge that the corporation had been created or had not been created. Excuse me. So it's actual knowledge. So you avoid this possibility by filing your articles of incorporation. Okay. The incorporators are one or more persons who delivered the articles to the Secretary of State for filing. Now, there's mandatory and discretionary provisions for the articles of incorporation. Your best bet is going to be to memorize this list of mandatory provisions, because pretty much anything can be a discretionary provision. The statutes lay out a couple, but you're really, the only way to ensure that you're in good shape is to know the mandatories. Okay, so the first mandatory provision in the articles is the name. So the corporate name must be distinguishable from other corporate names. But note while we're there that distinguishable is a pretty slim margin. It could be a comma placement is sufficient to be distinguishable. So just be really careful about that particular area. The name must contain language indicating that the entity is a corporation. So like corp, co, inc, that kind of stuff. It may not imply an illegal purpose. So for instance, Florida Medical Pot would be no good at this point. It may not imply a connection with a state or federal agency. B, they must contain the address of the initial principal office. C, the number of authorized shares. So again, that's the number of authorized shares. The number of authorized shares is to be distinguished from the number of issued, outstanding, and treasury shares. We're going to get to an example laying out the difference amongst those 4 categories in a little bit. D is preemptive rights. And if you go down to the footnote there for preemptive rights, although the only opt-in provision mentioned in the sections, the mandatory provisions section, is preemptive rights, cumulative voting and par value are also opt-in provisions. So if you're going to have cumulative voting or par value, they also must be in the Articles of Incorporation. Okay, E, the address and name of the initial registered agent. F is the name and address of each incorporator. For some reason, when they test this subject on the bar, they like to test whether, like, the name of the shareholders has to be in the articles, or whether the name of all the directors have to be in the articles, those kinds of things. And they're not in our mandatory list. So, 2, the discretionary items in the articles of incorporation are generally the names and addresses of the initial directors. So again, that's a discretionary provision. The purpose statement, provisions regarding management, corporate powers, par value, and any liability of shareholders for the debts of the corporation.
What number is that?
22. Is it 22? Is any liability?
I'm way off on all of
I'm missing a lot of
them. Yeah.
Okay.
really fast.
Sure. Should we start up at sub 2, the discretionary items?
Yeah.
Okay. The discretionary items in the articles of incorporation are names and addresses of the initial directors, a purpose statement, provisions regarding management, corporate powers. Sub 21 is par value. And sub 22 is any liability of shareholders for the debts of the corporation. Okay. So now, under Florida law, a corporation can be formed for any lawful purpose. Further, except under very limited circumstances, the validity of a corporate act may not be challenged as being ultra vires.
Can you repeat that?
Sure. The validity of a corporate act may not be challenged as being ultra vires or ultra vires, depending on who you had for corporations.
What exactly does that mean?
Beyond the power of. You used to be able to prosecute or defend corporate action by saying the action was beyond the purpose of that corporation. Now, under Florida law, you can have very broad purpose statements. So you could basically say any lawful purpose would be sufficient. Under previous corporate statutes, and in some states, you have to limit your purpose statement. So if you're only buying and selling real estate, and that's your corporate power, anything that's not buying and selling real estate would be considered ultra vires. But Florida's really done away with that doctrine, except in the circumstances we'll get to next. Okay, so corporate action may be challenged by a shareholder, so it may be challenged by a shareholder to enjoin. Okay, it can be challenged by the corporation. And continued on the next page, that can be challenged by a corporation itself against a former or current officer. And then by the Attorney General. To dissolve or enjoin. So notice here, when we're talking about the shareholder or the Attorney General, the shareholder's remedy is only injunctive relief. There's no damages there. Okay? And the Attorney General as well can only either dissolve or enjoin the action. Okay. B, a validly formed corporation has all the powers of a natural person. That includes the right to sue, to lend money, and to make charitable contributions. The charitable contributions can be made for public welfare, charitable, scientific, or educational purposes. Okay. B, another corporate characteristic is free transferability. The ownership interests of a corporation are divided into shares. The shares are the units in which the proprietary interests in the corporation are divided. The number of authorized shares is the total number of shares that the corporation is authorized to sell. The number of issued shares is the number of shares which have been sold. The number of outstanding shares is the number of shares which are actually currently owned by the public. Now, 4, the number of treasury shares are authorized and issued but are not outstanding. So now we're going to do a quick example. So our facts are Corporation X has 500 authorized shares. It sold 300 shares on July 7th, 2010. It reacquired 150 of those shares on December 7th of 2010. It then sold 100 shares. So I'll give you a minute to start to sketch out how many shares are issued, outstanding, in Treasury, and then we'll go over them. Sorry about the page break. That's an unfortunate placement. OK, all set? OK, so how many shares are issued? There's 400 shares that have been issued. OK, so we sold 300, and then we sold an additional 100. So that makes up our number of issued shares. For how many shares are outstanding? Oh, sure. The issued are the total number that have been sold. So we initially sold 300, and then sold an additional 100. So that makes 400 issued. OK, how many shares are outstanding? There's currently 250 shares outstanding. OK? And how many shares are Treasury? There were 150 that were bought back. 150. They're the total number reacquired. And they don't lose their Treasury share status by being resold. So, yeah, it's a little goofy, but. OK. So 6.
So
sorry.
if shares are in Treasury and the business sells those shares in the marketplace, gets the money for them, it's still counted.
They're still counted as Treasury, and now they've been reissued.
You have an asset in Treasury stocks that you don't own, and you also have the cash that's taken out?
That's the way it's written under the Florida statutes. It is strange, but OK, 6. On the bar, I've seen them ask a lot about outstanding and issued. So make sure you're pretty familiar with those two concepts. They don't ask as often about Treasury, probably because it is somewhat misleading under the statutes. 6, a corporation may have classes of shares. Each class must be distinct. And all shares in a class must have identical preferences, limitations, and relative rights. Okay. There must be at least one class of shares with unlimited voting rights. and at least one class of shares with unlimited economic rights.
They could be one and the same?
Absolutely. If you only have one class, your common would have unlimited voting in economic. The economic rights are the rights to receive the net assets upon liquidation. So these are the rights to receive the net assets upon liquidation. Free transferability generally indicates an ability at any time to sell one's shares. However, a corporation can restrict the free transferability of shares, but the restriction must be conspicuous. So it must be conspicuous on the certificate or the info sheet which accompanies the shares. Remember in Florida that shares don't have to be evidenced by certificates. But if you don't issue share certificates, you have to issue an info sheet which basically has all the same information on it. Okay, an example of a restriction could be that purchaser may not sell within the first 6 months of acquisition, or that the corporation or other shareholders have a right of first refusal to purchase the proffered shares. Now, for these purposes of conspicuous, we're really looking for a different font. It could be in bold, it could be italicized, it could be underlined. Okay, a purchaser for value will not be bound by a restriction of which he has no notice. So a purchaser for value will not be bound by a restriction of which he has no notice and which was not stated on the certificate or info sheet. Okay. Under preemptive rights, so with respect to preemptive rights, if a corporation desires to have preemptive rights, the presence of preemptive rights must be contained in the articles. So that's one of those opt-in provisions. A preemptive right is the right to maintain a proportionate amount. So a preemptive right is the right to maintain a proportionate amount of unissued shares upon their issuance. A preemptive right may be waived. And a waiver, if in writing, is irrevocable, even if there is no consideration. Okay, so 55 is in writing. Yeah. So if it's in writing, it's irrevocable, even if there's no consideration. A shareholder does not have preemptive rights with respect to first, shares issued as compensation. Okay. Or shares issued for consideration other than money. Okay. Sub 3, shareholders. Shareholders are the owners of the shares of the corporation. Shareholders can purchase their shares for any consideration, including first, money. Second, promissory note. Third, services performed. In other words, past services. D is future services. If evidenced by a written contract. So future services if evidenced by a written contract. And lastly, other securities of the corporation. Three, the board determines the adequacy of the consideration received. So in other words, to value the past services or future services evidenced by written contract, the board is the one to determine if that would be adequate for payment for the shares. Shares may be acquired by subscription. A subscription for shares is irrevocable. So it's irrevocable for a period of 6 months. Unless the subscription agreement calls for a longer or shorter period, or all subscribers agree to revocation. Okay. To be enforceable, a subscription agreement must be in writing. So, must be in writing and signed by the subscribers. Shareholders may receive distributions. So a distribution is a direct or indirect. So a direct or indirect transfer of money or other property, except the corporation's own shares, or the incurrence of indebtedness. So a distribution is a direct or indirect transfer of money or other property, except the corporation's own shares, or the incurrence of indebtedness by the corporation to or for the benefit of the shareholders. Okay. In order to make a distribution, any distribution must be authorized by the board. The record date for any distribution is the date the distribution is authorized. The record date is the date on which the corporation determines the identity of its shareholders and their interests. Okay. There are two tests for making distribution. The first is equity and solvency. Under the equity and solvency test, the corporation must be able to pay its debts as they become due in the regular course of business. Two is the balance sheet test. Under the balance sheet test, the total assets must be at least equal to the sum of the total liabilities plus the amount needed to satisfy any preferential rights. We're going to do an example on that later. So finally, a share dividend. So, a share dividend is a distribution of shares. So it's a distribution of shares on a pro rata basis and without consideration. A share dividend is not required to meet either the equity and solvency or the balance sheet tests. And they like to try to make you say that it does. So be careful with that. In other words, if they're talking about a share dividend and then they start kind of laying out facts about assets and liabilities, you can largely ignore those facts because the share dividend doesn't have to meet balance sheet or equity and solvency. 6, shareholder meetings. The annual meeting may be held in or out of the state. And for whatever reason, they like to question that too. They'll have the annual meeting be in the islands or something and ask you if that's okay or if it's a waste of the corporation's money. As long as there's no other restriction, they can hold the annual meeting wherever.
Maybe you went over this before, but corporations, partnerships, agency, or besides agency, the corporations, partnerships, always multiple choice on the bar?
Yeah. I've never seen an essay.
Okay.
I mean, I suppose they could because the bar examiners can
That's what
can do whatever they want.
On the lecture, could be, but.
But historically, I'm not aware of a single time they've tested it by essay.
Just making sure.
Yeah.
We're going to get it.
Well, we might get
Well, that's
agency,
dour.
so-
Yeah. Okay, so that's your annual meetings. Your special meetings are limited to the purpose set forth in the notice. So under notice, this at least is the same rule. For your annual meetings, you're entitled to at least 10 days notice, but not more than 60. And it's the same for your special meetings. You're entitled to at least 10 days, but not more than 60. And keep in mind that that's for shareholder annual and special meetings. The directors have different rules. So now voting. Generally, it's 1 vote for 1 share. Okay, shareholders may vote by proxy. A proxy is valid for up to 11 months and is generally revocable. Unless the proxy document states it's irrevocable and the proxy appointment is coupled with an interest. Okay, an interest for these purposes may be a pledge or a contract for sale. An irrevocable proxy becomes revocable when the interest it is coupled with is extinguished. 3, a quorum is required for any action. I've got a typo there, it shouldn't be if. So a quorum is required for any action. A majority of votes. So, a majority of votes entitled to be cast at a meeting constitutes a quorum. A quorum cannot be broken by a shareholder leaving. They like to test that too. People show up, they get counted, and they don't agree with the corporate action, so they leave thinking that they'll cause a non-vote. You can't break a quorum by leaving. The required number from a quorum may be reduced from a majority. So your default rule for a quorum is a majority to not less than 1/3. Okay, so cumulative voting. If cumulative voting is authorized, a shareholder may cast as many votes for directors as a shareholder has shares, multiplied by the number of directors to be elected. We're going to do an example on that later, too. Cumulative voting encourages minority representation on the board. But the effect of cumulative voting can be defeated by classes for directors or by reducing the number of directors. Okay, so now voting arrangements. A voting trust. Classes.
Do you have the answer sheet for this?
Sarah does. Yeah. I mean, I've got one too. I can see afterwards, but Sarah's got all the answers too. Okay. So voting arrangements. First, a voting trust. A voting trust separates legal and beneficial ownership. Shares are actually transferred to the trustee. And the trustee is under a duty to file a list of participating shareholders with the corporation. The second type of voting arrangement is a shareholder agreement. Shareholders' agreements, shareholders' agreements are private contracts which are specifically enforceable if in writing. Okay, while we're here, an important difference between the two of these is that you'll notice the voting trust has to be registered with the corporation. The shareholder agreement can be a secret agreement. Nobody else has to know about it except for the participants. They also like to test that the shareholder agreements are specifically enforceable. In other words, the court will order somebody to act in accordance with that agreement. And they try to make you say that the court wouldn't order somebody to vote a certain way, but under shareholder agreements they would, because they're specifically enforceable. So since we're addressing shareholders, let's talk briefly about derivative actions. Okay, in order to bring a shareholder derivative action, the person must have been a shareholder when the transaction complained of occurred. So they must have been a shareholder when the transaction complained of occurred, or have become a shareholder through operation of law. So for example, through inheritance. Shareholder. Yeah. Then 113 is inheritance.
The timing of the inheritance, does it matter?
Not really. No. I've never seen a place where it makes a difference. Where you typically see this is a corporation starts taking some kind of action, like, for instance, BP after the oil spill. There were a lot of people that went out and tried, a lot of environmental activists that went out and tried to buy BP so that they could then have an action against BP for this oil spill. Since they acquired after the transaction complaint have occurred, they cannot bring a shareholder derivative action, so they'd have to find some other remedy. You see it a lot with, like, it's mostly the environmental and the animal rights that you kind of see this occur, but it does come up occasionally. So A, the complaint in a derivative action must be verified. So it must be verified and alleged with particularity. So verified and alleged with particularity the demand made to get the board to act. This is known as the universal demand requirement. Okay. If the court finds that the board or advisory panel made a reasonable investigation of the shareholder's issue and concluded in good faith So concluded in good faith that maintaining the action would not be in the best interests of the corporation, the action will be dismissed. So that's a pretty important distinction, this demand requirement. If you fail to make a demand upon the corporation to remedy whatever action you're complaining about, the court will dismiss it out of hand. So once brought, a derivative action may not be discontinued or settled without court approval. So 8, when we're looking at fundamental changes, since we're still talking about shareholders, we'll talk about fundamental changes. In the event the corporation is undergoing a fundamental change, for existence, a merger, a merger or a sale of all assets, or a share exchange, you want to consider who's going to be affected by the change. So if you're looking at like a merger where Corporation A is acquiring Corporation B, Corporation A's shareholders' rights aren't fundamentally affected, but shareholder B's shareholder rights certainly are. So the B voters, or the B shareholders, would get the right to vote on that fundamental change. Okay. So the affected party is the party who gets to vote. So now, sub of this is the appraisal rights. Appraisal rights are not available. So appraisal rights are not available if the shares are listed on a public exchange, or there are at least 2,000 shareholders and 10 million of value. So a corporation must give shareholders notice of the existence of appraisal rights in the notice of meeting. A shareholder wishing to assert his appraisal rights must deliver notice of intent to demand payment. If the action is affirmatively voted, the corporation must send notice of the approval within 10 days and give the shareholders a form to assert their appraisal rights and make an offer of appraisal and make an offer of value. Excuse me. Sure. Public exchange. So, yeah. The shareholder must execute and return the form to the corporation with the demand of payment or accept the corporation's offer. If the corporation disagrees with the shareholder's assertion of value, it must submit the matter to the court within 60 days. Again, that 60 days is an absolute. So if you blow your time period, you're barred.
The corporation, the appraisal rights are already asserted.
Right, but the action to compel has to be, yeah. Okay, our next corporate characteristic is centralized management. The management of the corporation is centralized in its board of directors. The board of directors must be made up of individuals. So at least statutorily in the state of Florida, a corporation can't serve on the board of directors of another corporation. It has to be natural people. The director must be at least 18 years old and is not required to be either a Florida resident or a shareholder of the corporation. They like to test on that Florida resident. Not sure why, but now a director may be removed with or without cause, or a director may resign by delivering his resignation in writing to the board. The board sets its own compensation, and this is not considered self-dealing. Okay. Regular meetings of the board of directors may be held without notice of the purpose of the meeting. So regular meetings of the board of directors may be held without notice of the purpose of the meeting. And a special meeting must be preceded by at least 2 days' notice of the date, time, and place. The notice need not describe the purpose. Okay, so to contrast that to your shareholder meetings, right? For a special meeting of the shareholders, you have to specifically describe the purpose of the meeting. For any action to be effective, a quorum must be present at the meeting to vote on the action. So again, just like with shareholders, a quorum generally consists of a majority of the board. So it generally consists of a majority of the board, but the articles may authorize a quorum to consist of less than a majority, but no fewer than 1/3. So at least for these purposes, that's identical to our shareholders with respect to quorums. Okay, now director duties. Directors must act in good faith. So they must act in good faith with the care of an ordinarily prudent person in a like position They must act in good faith with the care of an ordinarily prudent person in a like position under similar circumstances and in a manner that he believes to be in the best interest of the corporation. Okay. In making his decisions, a director is entitled to rely on the opinion of experts. For instance, accountants, attorneys, officers, or employees. And a director may, in making decisions, consider the long-term prospects of the corporation, okay, the interests of the shareholders, the social effects of the action taken, the communities in which the corporation operates, and the economy. It's the economy of the state and the nation. The most important ones through here, or the perceived trickiest ones, are that the director can consider the social effects of the action taken. Okay. 9, a director is not personally liable for monetary damages unless first the director failed by action or omission to perform his duties. So the director failed, and such breach or omission constitutes first a criminal act, a transaction from which a director derived an improper personal benefit. So that's an improper personal benefit. 3, in a derivative action where the breach or omission constituted conscious disregard for the best interests of the corporation or willful misconduct. Or the breach or action constituted recklessness, was committed in bad faith, with a malicious purpose. I think you guys have probably been through enough questions at this point that you sort of know when they're trying to test on recklessness. You know it when you see it. Recklessness has to be pretty overt to be identifiable as such. So now the exception to centralized management is in a corporation of 100 or fewer. It's 100 or fewer shareholders. An agreement may be made to change the governance scheme for the corporation, even to go so far as to get rid of the board. If such agreement is entered, it must be set forth in the articles or made by unanimous agreement. You'll generally see this type of agreement in a corporation with 3 or 4 shareholders. You generally don't see it with 99 or 100. That would be reasonably unworkable. An action by a director, which would otherwise be a conflict of interest, will not be improper if first, the relationship or interest is disclosed, and the contract is ratified without counting the vote of the interested party, although such interested party may be counted for quorum purposes. Or B, the action is ratified by shareholders after disclosure. Or C, the contract or transaction is fair at the time it was authorized. Okay, so liability for improper distributions. A director who makes a distribution which violates either the equity insolvency or the balance sheet tests is personally liable to the corporation. It's personally liable to the corporation to the extent that the distribution was improper. Now, with respect to limited liability, the liability of a shareholder for corporate action is extremely limited. A shareholder is obligated to pay full consideration for his shares. That's full consideration there at 176. The veil of a corporation may be pierced, thus making the shareholders individually liable for the debts or liabilities of the corporation if the shareholders have participated in fraud or illegal conduct which has led to the debt or liability. And that's sort of our greatest hits of corporations. I know you guys have outlines and questions and all that stuff, so I try to just hit on the places that they tested when I took it, I guess, and what I've seen historically in the questions. Okay? Do you guys want a break, or you want to just kind of keep rolling through? Because the other entities don't take as long as corporations. Okay, cool. So the second here, we're going to go to not-for-profits. And we're really going to talk about not-for-profits to the extent they differ statutorily from regular corporations. So first are the required content of the articles of incorporation. One is the name. 2, the street address. 3 is the purpose. And that's our most important one. So if you're talking about a not-for-profit, it has to have a specific purpose statement in its articles. 4 is a statement providing the method for electing directors. 5, any provision limiting the corporate powers otherwise provided under the Florida Statutes, Chapter 617. 6 is the street address of the initial officers and the name of the initial registered agent. And then 7th is the name and address of each incorporator. Now, the permissive article, or the permissive content in the Articles of Incorporation is a little different than our for-profit corporations under Chapter 607. First is the name and address of the initial directors. Second, provisions regarding regulation of internal affairs. And third is sort of where it gets interesting. The manner of termination of membership. For whatever reason, under the Florida statutes, you're a member in a not-for-profit, but you're a shareholder in a for-profit corporation. It's bizarre, I don't know. So the manner of termination of membership. Fourth, or sub 10, is the rights upon termination. The rights of a member upon termination. Next is the transferability or non-transferability. Finally is the distribution upon liquidation or dissolution. Okay. Now, your purpose statement, like we said, you have to specifically set forth your purpose statement, your articles for a not-for-profit. And generally, a not-for-profit can exist for any lawful purpose. So for any lawful purpose, it's not for pecuniary profit.
Can you repeat that?
Sure. It can exist for any lawful purpose, but not for pecuniary profit. Okay. Now, distributions, when it comes to a not-for-profit. The corporation may not make distribution to its members, directors, or officers. So it may not make distribution to its members, directors, or officers, but it may pay compensation. Now, when you're thinking about not-for-profit compensation, I don't know if like the Palm Beach Hospice made the news much down here, but they were paying their executive director something like $725,000. And that was met with a lot of outrage. But they were able to establish that directors in similar positions in similarly sized charities made about that much money, so it's reasonable. Okay, so you're really looking at what the market supports and what other similar corporations pay as compensation. So. Okay, so now distribution may, however, be made upon dissolution. Okay. B, a corporation may purchase its memberships if after the purchase, the balance sheet and equity and solvency tests are met. Okay, so those are the same tests that we saw when we were talking about distributions under a for-profit. 4 is members. So like we said, this chapter refers to holders of an interest in a not-for-profit as members rather than as shareholders. And you can read legislative history till you're blue in the face. It doesn't explain why. So. B, members have no voting rights except as set forth in the articles. C, the liability of members. Liability is limited to dues, assessments, or fees. So, liability is limited to dues, assessments, or fees. D, interests are generally not transferable. E, resignation of a member does not relieve the member from obligations that arose prior to resignation. And F, a member may only be suspended or terminated pursuant to a procedure that is fair and reasonable. Fair and reasonable, and carried out in good faith. Okay. 5, when we're talking about directors in a not-for-profit, the board must consist of at least 3 individuals. So contrast this back to our for-profit corporations. There's no minimum or maximum number of directors in a for-profit. But in a not-for-profit, you must have at least 3. Okay, so those are sort of the important variances between for-profits and not-for-profits. So now LLCs. So management of an LLC, it may be member-managed. So it may be member-managed or manager-managed. If it's manager-managed, I know that's redundant, but there's no other real way to say it. So if it's manager-managed, then it's conducted like a corporation with a board. Okay. Your management of an LLC owes a duty of good faith and a duty of care. Now, an LLC is governed by an operating agreement. So an LLC is governed by an operating agreement. And there are certain non-waivable provisions in the operating agreement. The first, you can't unreasonably restrict access to books and records. So our threshold there is unreasonable. That's kind of like recklessness. You sort of have to know it when you see it. 2 is eliminate the duty of care. So notice again, that's completely eliminate. So you can certainly limit the duty of care. 3, unreasonably reduce the duty of loyalty. 4 is eliminate the obligation of good faith. So again, that's eliminate the obligations of good faith and fair dealing. 5th, vary the requirements to wind up. Or 6th would be to restrict the rights of a person who is not a manager, member, or transferee of distributional interests.
Winded requirements statutory then?
It is,
Okay.
yeah. So 3, with respect to new members, when you're talking about admitting new members to an LLC, a majority of members must consent in writing to the admission of a new member. Okay. 4, a person ceases to be a member if he makes an assignment of his interest for the benefit of his creditors. He files a voluntary petition for bankruptcy. Or C, he is adjudged bankrupt or insolvent. When I was in law school and I was studying this, I thought that particular thing would come up a lot in practice, and it has not. Been a little disappointed. 5, distributions. No distribution may be made if, after giving it effect, the LLC would be insolvent. So contrast this to your corporations law. We don't need to look at the equity insolvency or the balance sheet test. We're just looking for pure insolvency after the distribution. 6, transferability. A member may assign his economic interests. So a member may assign his economic interest, which is the right to receive distributions, or to receive a pro rata share of the net assets following liquidation, but may not assign his voting interest. Okay, now liability of members. It's specifically directed by statute that if the question of individual member liability should arise, to use corporate case law. So when you're looking at piercing situations, you're going to apply corporate case law. So look for fraud or illegal conduct. Okay, personal liability in an LLC is limited to full payment for, rather than shares, it should say interest there. So personal liability is limited to full payment for interests. Now, 8, records. The LLC shall keep as records, first, a list of all members. Second, a copy of the articles. So a copy of the articles. Third, a copy of the last 3 tax returns. Fourth is a copy of the operating agreement. Fifth is a statement laying out the amount contributed by each member. Okay. And it shall provide access to the records for a member or their legal representative. Member or their legal representative. Contributions for LLC interest can consist of cash, property, services rendered, so it's cash, property, services rendered, a promissory note, or an agreement to perform services. A member's contribution may be compromised. So, a member's contribution may be compromised with the consent of all members. Okay, so now standards for a manager. Your manager owes a duty of loyalty. This duty of loyalty consists of the duty to account. So the duty to account, to not deal adversely, and to refrain from competition. Okay. B, your manager owes a duty of care, which means he can't act in a grossly negligent. So can't act in a grossly negligent or reckless fashion, or in a manner indicating a knowing violation of the law. So under the LLC Act, we're apparently okay with an inadvertent violation of the law. C, must act in good faith and deal fairly. D, in the event of conflicts of interest, if the conflict is fair and reasonable. So if it's fair and reasonable, or it's disclosed and approved. So if it's fair and reasonable, or disclosed and approved, The transaction is not void or voidable. 11, the Olmsted patch for personal liability. In a single-member LLC, if a judgment creditor shows that distributions will not be enough to satisfy the judgment creditor may go beyond a charging lien and force the sale of the interest in the LLC pursuant to a foreclosure sale. In this event, the purchaser receives the entire interest. So they receive the entire interest, and the purchaser becomes a member. So as you're advising LLC folks, you can't have a single-member LLC in Florida any longer and enjoy limited liability. So even if you give another person 1%, that's sufficient to overcome this. B, in a multiple-member LLC, foreclosure is not available, and a charging lien is the only remedy. Charging lien.
With both, they still have to go after all the assets in the LLC first before they.
Sure, yeah. But it's made it really dangerous for single-member LLCs. And there's a lot of them out there, because it's not like we publicize this real well. Which is made for more work, because you go back to all the people you formed LLCs for, and Okay, now appraisal rights, like in a corporation, but they're not available if the LLC is listed on a public exchange or has more than 500 members and 10 million of value. So just distinguish that back to the corporation. For a corporation to not have appraisal rights, they have to have at least 2,000 shareholders and 10 million of value, okay? So now partnerships. First, with general partnerships. So what is a partnership? It's an association of two or more persons. So an association of two or more persons to carry on as co-owners a business for profit. Okay, a partnership is a separate juridical entity. It can sue and be sued. It can hold property, but it's a pass-through entity for tax purposes. In other words, a partnership's taxed at a single level. 3, the partnership statutes are default rules. The partnership agreement is the governing agreement, but the partnership agreement cannot, first, change any filing requirements. So it can't change any filing requirements. It can't eliminate access to books and records. So notice again, that's an absolute elimination. So you can restrict access pretty good. And C, entirely eliminate the duty of loyalty.
Can you read that?
Sure. Which part?
Entirely eliminate.
The duty of loyalty. Okay, 4, formation. A partnership is formed when the definition is met, regardless of the subjective intent of the parties. So the following factors are not by themselves sufficient to find a partnership. First, holding property as joint tenants, tenants in common, tenants by the entirety, joint property, community property is part owners. 2, the sharing of gross returns.
Share what?
Gross returns.
Gross return?
Gross returns. 3, but when you're looking at profits, when profits are shared, one is presumed to be a partner, unless the profits are received as payment on a debt, for independent contractor services, or as rent. Okay. B, partnership capital is made up of contributions by partners. C, property can be acquired by the partnership first. Property is partnership property if it's acquired in the name of the partnership. Second, it's acquired by one acting in his capacity as partner. Two, property is presumed to be partnership property if it's purchased with partnership assets. Three, property is not partnership property if it's acquired only in a partner's name. So if it's acquired in a partner's name, even if the property is used by the partnership. D, with respect to agency, each partner is an agent of the partnership. An act of the partner in the usual course of business binds the partnership. So, an act of the partner in the usual course of business binds the partnership. An act of a partner outside the ordinary course of business binds the partnership if he acts with the authority. He acts with the authority given by all other partners, or such action is authorized in the written partnership agreement. E, partner's liability. A partner is personally liable for all partnership obligations. But there's no personal liability for debts incurred by the partnership prior to that person becoming a partner. 2, a judgment against the partnership is not by itself a judgment against a partner. A judgment against a partnership may not be satisfied from a partner's assets unless there is also a judgment against the partner. F, purported partners. A purported partner is liable where he represents or allows himself to be represented as a partner to any third party who relies on the representation. 5, partner rights and duties. Each partner has a partnership account. The partnership account consists of money and property contributed, and distributions made by the partnership, less liabilities distributed, and shares of partnership losses. The partnership accounting rules are really complex, and so I've never actually found a question where they try to get you into the math of partnership accounting. I think Barbary has a couple, but I don't think the bar examiners have ever actually done that. So B, each partner has equal rights in management. C, each partner can only use partnership property to benefit the partnership. D, each partner is entitled to reasonable compensation. So, each partner is entitled to reasonable compensation for services in winding up, but not compensation for services performed for the partnership. So, E, decisions within the usual course of business are by a majority. So decisions within the usual course of business are by a majority, but decisions outside the ordinary course must be unanimous. F, a person may only become a partner upon the consent of all of the partners. G, a partner is not entitled to receive distributions in kind. 6, a partner's right to information. Each partner has the right to access books and records, including the right to inspect and copy. 7, standards of conduct, care, and loyalty. First, we'll look at loyalty. A partner must account. So a partner must account for any personal profits received in connection with partnership business. 2, a partner may not deal with the partnership in an adverse way. And 3, a partner must refrain from competition with the partnership. So B, care. A partner can't act in a grossly negligent. So a partner can't act in a grossly negligent or reckless way or with intentional misconduct. And C, a partner also owes the duty of good faith and fair dealing. So 8, actions by partnership and partners. A partnership can bring an action against a partner for breach of the partnership agreement or for a violation of a duty owed where the violation caused harm to the partnership. And B, a partner can bring an action to enforce his rights under the partnership agreement or to enforce other rights under this act. The partnership owns partnership property. The partners don't own it as co-owners. Now, with respect to transferability in a partnership, a partner can only transfer his economic interest. So a partner can only transfer his economic interest in the partnership, which means his share of profits and losses, his right to receive distributions, but not his interest in management. 11, dissociation. A partner can dissociate by giving notice of his express will to immediately withdraw. partner can dissociate upon the occurrence of an event specified by the partnership agreement. C, a partner can dissociate by being expelled. So you can dissociate by being expelled by a unanimous vote of the other partners if first, it is unlawful to carry on with that partner. You see that type of thing often with law firms. If somebody gets disbarred, obviously it would not be ethical or practical to carry on with that person as a partner. Or 2, if that partner has transferred all of his transferable interests. 12, wrongful dissociation. A dissociation is wrongful if first, it's in breach of the partnership agreement. Or if before the expiration of the partnership term, a partner withdraws. Or a partner is expelled by judicial order. Or 3, a partner is a debtor in bankruptcy. Now, I would think that, there's been a lot of lawyers that have been disbarred here lately, both in the foreclosure crisis and in some of the other financial scandals. So I would think some of these questions are probably fairly ripe for the bar examiners to hone in on. 13, effect of a partner's dissociation. A partner's right to participate in management and conduct terminates. So a partner's right to participate in management and conduct terminates. B, a partner's duty of loyalty terminates. However, the partner's duties of care and loyalty continue for transactions occurring before the dissociation. Okay. 14, a dissociated partner can remain liable on transactions occurring up to 1 year. So, for transactions occurring up to 1 year after the partner dissociates, if first, the other party believes he was still a partner and did not have notice. B, however, the partner can file a notice of dissociation, and then he will remain potentially liable for 90 days. So the 91st day after filing, it's considered public notice. So 15, dissolution. A partnership at will dissolves when a partner withdraws. B, a partnership for a definite term dissolves within 90 days. So it dissolves within 90 days of a partner's dissociation by death or wrongful dissociation. 2, it dissolves where it is the express will of all partners to wind up. 3, it dissolves at the expiration of the term. 4, it can dissolve at the happening of an event specified in the partnership agreement. Or 5, it dissolves on the application of a partner and it is judicially determined that first, the economic purpose is likely to be unreasonably frustrated. So the economic purpose. 2, it is not lawful to carry on with a partner. Or 3, it is not reasonably practical to carry on pursuant to the partnership agreement. 16, a partnership continues until it finishes winding up. However, the partnership can waive. So the partnership can waive its right to wind up and terminate the partnership if first, the partnership resumes business as though the dissolution never happened. Or 2, the failure to wind up will not adversely affect a third party. Okay, so now we're on to limited partnerships. With respect to limited partnerships, generally a person can be both a general and limited partner, with his duties dependent upon which capacity he's acting in. This changed reasonably recently. When I was in law school here, I graduated in 2004, you could only be a general or a limited partner. They changed that, I think, in 2006. So 2, a limited partnership has a distinct existence. 3, the certificate. A certificate of limited partnership must be delivered to the Department of State. The certificate must include the name, Now, the name of an LP may contain the name of any partner, including a limited partner. Again, that's been a change since 2006, so we're probably about to where the questions are starting to catch up with the statutes. 2, the name must include some indication of its limited status. For instance, LP, LIM, LTD, those kind of designations. B, the name and business address of each general partner. C, whether the partnership is an LLLP. And D, where there has been substantial compliance with these requirements, the document, is effective when filed. 4, the records office. The LP must designate and maintain. So it must designate and maintain a designated office and a registered agent and registered office. B, the records office must contain, first, a current list showing the full name and street address of each partner. And it must separately identify the general and the limited partners. 2, it must contain copies of filed documents, or it must maintain copies of filed documents. 3, copies of the last 3 tax returns. 4th, a copy of any partnership agreement and all amendments thereto. 5, the partnership agreement. This is a document that governs the relations among partners and between the partnership and partners, but the agreement cannot, first, vary the power to sue and defend in its own name. So it can't vary the power to sue and defend in its own name. It can't vary the applicable law. It can't vary the maintenance and signing requirements. Can't restrict the right to information. Fifth, or sub 14, can't eliminate the duty of loyalty of the general partner. It can, however, identify specific types of activities that do not violate the duty of loyalty. 6, can't unreasonably restrict the duty of loyalty of the general partner. 6, limited partnerships, unlike partnerships, can carry on not-for-profit activities. 7, the form of contribution can be any pecuniary benefit. So that can include, for instance, money, services performed, promissory notes, other agreements to contribute cash or other property, contracts for services to be performed. B, the liability for contribution. The obligation to contribute shall be a record signed by the partner. So performance is not excused by death, disability, or other inability to perform. Sharing of profits and losses. These are allocated on the basis of the value of the contributions. So 8, the liability of a general partner. All general partners are jointly and severally liable. So all general partners are jointly and severally liable, but not for obligations arising before they became a general partner. This is another place that the statutes need to be cleaned up. But until they are, we deal with joint and several. Okay. B, the limited partnership itself may be liable for loss or injury occurring as a result of a wrongful act or omission or other actionable conduct of a general partner acting in the ordinary course of activities. 9, the liability of a limited partner. The obligations of the limited partnership are not the obligations of a limited partner, whether in contract or tort, even if the limited partner participates in management. Management. And that's, again, a 2006 change. It used to be if a limited partner participated in management, they became liable for the acts. 10, the rights of partners. A limited partner has no power to act for or to bind the limited partnership. A limited partner can inspect and copy documents after 10 days' notice. No particular purpose is necessary with respect to required information. But with respect to information on the state of activities or the financial affairs of the LP, they must have a purpose directly connected So they must have a purpose directly connected to the limited partner's interest as a limited partner. The limited partner must make a request describing the records requested with reasonable particularity. The information sought must be related to the purpose. So it must be related to the purpose. So management rights. Each general partner has equal rights in management. So each general partner has equal rights in management. Decisions are generally made by a majority of general partners. But some decisions require the consent of all of the general partners. For instance, first, amendments to the partnership agreement. B is an amendment to the certificate of limited partnership. C, admitting a general partner. D, admitting a limited partner. E is expelling a limited partner. And F is dissolving the limited partnership. G is approving a merger or conversion. Approving. Yeah. 3, each general partner. So each general partner has the right to inspect required information and other information relating to the activities and financial condition of the partnership. Now, distributions with respect to an LP. A limited partnership may not make a distribution in violation of the partnership agreement. Two, if the equity and solvency test is not met. And 3 is if the balance sheet test is not met. B, a general partner who consents to a wrongful distribution is personally liable to the limited partnership to the extent the distribution is wrongful. 12, dissolution and dissociation. You must file a certificate of dissolution, and the certificate must include the name, date of initial filing, and the reason for the current filing. B, a limited partnership is dissolved upon first, an event specified in the partnership agreement. Or 2, the consent of all general and limited partners. C, winding up. After dissolution, the limited partnership continues only to wind up, and that includes the discharge of its debts and the filing of a statement of termination. Now, derivative actions with an LP. A partner need not first make a demand on the limited partnership if he can prove the futility of making a demand. So be really careful here when you're looking at any type of derivative actions. If you're in a corporate setting, it's a universal demand requirement. So without making a demand, your claim is barred. With an LP, if you can prove demand futility, then you can be excused from making a demand first. 14, the annual report must be filed. 15, the erroneous belief that oneself is a limited partner. So if one believes in good faith, that he is a limited partner, he is not liable for any obligations of the limited partnership simply by making an investment, by receiving distributions, or by exercising the rights of a limited partner. But he may be liable as to a third party who believes he's a partner, and this belief is in good faith. So those are sort of the highlights of BE. I have a couple of sample questions that we can go through.
In the shareholder derivative futility, you can't rely on futility either?
You can't rely on futility. There's a universal demand requirement.
Okay.
That will probably change over the next couple of years. Our legislature's been looking at it because it's really kind of a stupid requirement when you get down to the base level. But as of right now, it is statutorily required that you make a demand first. So, and especially when you're looking at a close corporation, if you're talking about two shareholders, it's really hard to ever make a demand that the corporation's going to take seriously.
Right.
So it really is bad policy, but it is the policy for now.
Right.
Okay? So let's go through the questions. Okay. I'll give you a minute or two to read the first one, then we can go through it, and then we'll do the same thing for the second and third. Do you guys want a break? I'm sorry. I'm not good at remembering breaks. Is this okay? We'll just wrap up? Okay. Cool. Yes, let's take like 3, and then we'll come back and wrap this up? Yes. Okay. Do they recycle here? Are there recycling bins, or there's just... Ah, thanks. Ready to start going through? Okay. So in the first question, I realized driving in here this morning that I should have provided some clarification. My intention was that the shares issued as compensation were separate from the 200 in the new issue. So we can go through it two ways, but the intention was that there were the 200 issued and then an additional 100, I guess, issued to the officers or the to the directors. Okay, so first,
Whoa.
yeah. So in my next version of these, that will have some clarification. So how many shares is shareholder X entitled to purchase? If we don't consider that the 50 shares issued to each director come out of that additional 200 issue. So in other words, let's just use the fact that there's 200 shares issued. How many shares is shareholder X entitled to purchase? That'd be 40, because he's a 20% shareholder. So he would be able to purchase to maintain a proportionate interest. Now, if we look at it as the additional 100 shares given as compensation to the directors did come out of that 200, then he'd be entitled to purchase 20 shares. In other words, again, 20% of what has been issued. Okay. So now, let's see, if shareholder X can't afford to purchase the shares, can he force the board to rescind the issuance? The answer to that is no. X's wherewithal to purchase the shares is not important. Just the fact that he was presented with the opportunity is enough. So if they completely denied him the opportunity, then he'd have some remedy. But the fact that he can't afford it is not an issue for the corporation. So now, can the board deny additional shares to Y after she waived her preemptive rights? Remember, in this context, the answer would be yes. A waiver in writing is irrevocable, even when not supported by consideration. Okay? So once you've waived, you've waived. Okay. Have you all had a chance to read too? Okay. So ABC has 100 common, 100 preferred. Preferred have a liquidation preference of $2 a share. They want to declare a cash dividend of $5 a share. Their balance sheet shows total assets of $10,000, total liabilities of $9,500, and shareholder equity of $500. Can ABC make a $500 contribution or $500 distribution? Excuse me. Anybody want to take a crack at it?
Maybe I'm doing it completely wrong, but
That's okay.
if the company owes $9,500 and distributes $500, then it would be at zero, so it would be insolvent either on the balance sheet or the equity.
But don't forget, you have to consider preferential rights too. We have a $2 per share preference.
Right, so 200 on top of that, so it'd be 200 in the whole.
Right. So you could only distribute 300.
Right.
Yeah, absolutely. You did it right.
So
The answer is no. They could only distribute $300. So remember that you want to look at assets versus liabilities plus the liquidation preference. So if $500 is distributed, what's the remedy? The remedy in that case would be that the directors are liable, as are the shareholders who received the distribution with knowledge, to the extent of the $200 which was improperly distributed. Okay, so they wouldn't be personally liable for the entire 500, just the part that was improper. Okay, so now C, corporation, or 3, corporation A has a 5-member board of directors. Shareholder B has 500 shares. Shareholder C has 700 shares. At an upcoming election, 2 new directors will be elected. The candidates for the board are D, E, F, and G. Shareholder B favors D and E, while shareholder C favors F and G. Can shareholder B be assured of electing one of his chosen candidates? And then what if the corporation has cumulative voting? Anybody want to try that one? Okay. In a straight voting scenario, B could only vote up to his 500 shares for any one candidate. Since we're only electing 2 directors, C will simply vote 700 shares for each of his preferred candidates, so B will not have representation on the board. But in cumulative voting, B could choose one candidate to accumulate his votes on. So in other words, he could vote all 1,400 of his voting units toward one candidate, or all 1,000, excuse me, of his voting units toward one candidate. Shareholder C has a total of 1,400 units to vote, but he can't accumulate in any way which would deny B a director. Okay, that's a fairly, I tried to make kind of a simple cumulative voting example. I know Barbary walks you through this giant formula. I haven't really seen that tested in a way that would require that kind of math. I mean, don't ignore it completely, but they generally don't make you do all kinds of equations.
But it's basically the amount of shares you have towards each director that needs to be put
Right.
a vote on. It's cumulative.
Right, absolutely. So you can accumulate your votes. So your minority shareholders have the ability to have a representation on the board. Okay? So that's my lecture.
So you're saying they can accumulate them all for one?
Yep. So you
Not
just,
stacking, they can take all three and put it on one?
sure, absolutely. Yeah. Okay?
Thank
Cool.
you very much.
Ah, sure.
You're not staying silent.